We have 3 segments for you today. Our first segment will be a panel of speakers. For our second segment, we will unveil an Academy Award video by our own Kenyatta Bartholomew, who was also a student of Law and Racism, along with remarks from our co-hosts in that same segment. And for our final segment, we want to hear from you and your comments about this issue with jury diversity and participation. Just for a rule of order, we want you to know that you are welcome to be active in the chat with your comments and questions, or you may hold your comments and questions for the third and final segment if you wish to speak them aloud. Thank you for coming, and I want to welcome you to the Symposium, Black Jurors Missing in Action or Missing by Practice. I will now begin segment 1. Our first panel speaker is Professor Angela Allen Bell. However, before she speaks, I wish to tell you about 2 op-eds by one of our Law and Racism students, Pedro Trevino, who sadly could not be here today. He has created 2 op-eds and their release is forthcoming. The first one is titled, Voter Suppression Received a Jury Duty Summons in Louisiana, and the second is titled, Equally Unequal, the Exclusion of Latino Jurors. Just so everyone is aware, for op-eds that are announced throughout the symposium, Ms. Severe will be placing their links in the chat as we go. To continue, Professor Angela Allen Bell is a respected local, national, and international legal scholar and expert on civil and human rights, social and restorative justice, and the interplay between race and justice. She is also one of the founding members of the advocacy team that led this effort to reform Louisiana's jury system through the adoption of legislation that would require unanimous juries in criminal trials in Louisiana state courts. She will provide some historical and geographical context to our discussion today, and she will explain how this all intersects with voting. Thank you again for joining us today, and I hope you enjoy this symposium.
Good afternoon, everyone, and thank you all for joining this effort. I want us to think about where we find the right to a jury trial in this nation. It is enshrined in all of the founding documents. You will find it in the Magna Carta. You will find it in the Declaration of Independence. You will also find it in the United States Constitution. So this would suggest to us that it is a cherished protection and even a preciously guarded right in this country. But there is such a thing as an ideal, and then we know there is practice and custom. In our legal system, accused people of color and jurors of color rarely get the ideal. More often, they get custom and practice. And for them, jury service, voting, criminal charges, and trials are inescapably intertwined with race. Now, you might even view this as a matrimony of sorts. I want us to consider the origins of this union that I speak to you about today. And that's going to require us to take a journey back to chattel slavery, right when it is slavery is ending in this country, and we are starting now Reconstruction. And this nation at that moment was struggling with some very fundamental questions. We enter Reconstruction not fully able to ascribe a meaning to this enormous thing called freedom. We really don't fully understand what citizenship should look like either for these newly emancipated people. And we see in the discussion of the very first Civil Rights Act, there's some talk about these perplexities. James F. Wilson stands before Congress and says, I quote, "Do they mean in all things civil, social, and political, all citizens without distinction of race or color shall be equal? By no means do we construe this as such. Do they mean that all citizens shall vote in the several states? No," he says, "for suffrage is a political right, which has been left to the states to control. Nor do they mean that citizens will now be able to sit on juries. Well, these things, as I understand them, are civil rights. Civil rights, he says, are just the rights to personal liberty, the right to acquire and enjoy property. So these concerns about political rights versus civil rights make their way onto the official Reconstruction records many times. And by political rights, I mean the right to vote. I mean the right to hold office, and I mean the right to jury service. And these concerns existed in Louisiana as well. So what was Louisiana's answer to these complicated questions? Voter suppression. That would happen immediately, and Louisiana had many creative approaches. The first one that we would see throughout the state is lynching to suppress the vote. The next one we would see would be acts of domestic terrorism all throughout the state. We see things like suppression of the vote through large-scale massacres in Louisiana, and then came the almighty use of law and practice to suppress the vote. And Louisiana officials did not have a desire to secret their bad intentions. So you would often see in the newspaper editorials things like the statement of Ora H. Snyder, who says, and I am quoting, "I am in favor of a proposition which will say every white man in the state shall vote because he is white. This is the lieutenant governor," I continue, "and no Negro should vote simply because he is black." Of course, we cannot put those words on the papers, but we can obtain this goal, so says the lieutenant governor. They aim at disenfranchising 75% of Negroes. Why not just disenfranchise them all? If we leave the right of suffrage to 10 or 20,000 Negroes in the state of Louisiana, these Negroes will hold the balance of power. And what could be worse? This is the words of the lieutenant governor. So what we are seeing through this is that many of these white Southerners, leaders as well as civilians, saw jury service as a form of political office holding at that moment. They were not going to allow blacks to become public service, not even in the jury box. And so jury suppression now begins to emerge with criminal justice. So if you're wondering, well, how was this accomplished? I would ask you to consider first and foremost how Louisiana officials decided on the number of black jurors that it would mute through its non-unanimous jury system. They used those voter registration records. And the voter registration records taught us that there might be around 3 blacks on those juries. So we set the law so that it would take 9 of 12 to convict. And then we want to consider Mr. Leander Perez, the known segregationist who 10 years after the Brown versus Board of Education decision absolutely refused to integrate schools in Plaquemine Parish. So he uses a simple confrontation between school children to criminalize 18-year-old Gary Duncan, who is a young black man in Plaquemine Parish. We see that it takes the intervention of the United States Supreme Court and the Duncan versus Louisiana opinion to correct this miscarriage of justice. So then you're probably saying that Leander Perez is hiding under a rock somewhere because he's humiliated, but that would not be what the facts bear out. 7 years later, we see Leander Perez simply decide he's going to create the interpretation test that we will now use in Louisiana to suppress black voters in Plaquemine Parish. You also wonder, how did this happen? You should know about Hunter versus Underwood in Alabama, where those officials decided that you could not vote in Alabama if you had ever been convicted of a crime called moral turpitude. So then how did they decide on the moral turpitude crimes that they were going to select? They simply asked the justice of the peace, what crimes do black folks get convicted of? And that, of course, became the law that they used to disenfranchise those Black voters. And then we should also know that most of the challenges to underrepresentation on juries in this country that end up before the United States Supreme Court, they come from Confederate states. And we certainly don't want to overlook who Louisiana disqualifies from jury service. That would happen to be certain felons, who I know Mr. Chico Yancey is going to talk more about later. And lastly, you do want to consider that at this present moment, where it is known and widely studied that if you exclusively use voter registration records to select potential jurors, Blacks and people of color will be underrepresented. But of course, Louisiana courts continue to defend the exclusive use of those voter registration records. So my plea today is that you will understand what is at stake. Political rights happen to be the lifeline of a people. It's the currency that people negotiate their freedom with. Granting full political rights in this country to people of color means that as a nation, we really need to reimagine what we mean by these words called freedom and citizenship. We might even need to rethink our unwillingness to share government with others. We may need to confront the many customs and court rulings that have taught us that Black skin is a mark of inhumanity and inferiority, and also renders one completely unfit to make judgments about a white person in this country. There is simply no other arena of government where racial discrimination is more apparent and more tolerated than in the selection of juries in America today. And tragically, the judicial system most often brands this conduct as legal. They sometimes even pretend not to notice. But the first lines of our United States Constitution suggest that the ends of government in this country should be justice, not legalities. So, ladies and gentlemen, we can no longer be married to law while it carries out an illicit affair with injustice.
Good afternoon, people of action. My name is Victoria Gonzalez, and I am a second-year law student at the Law Center. This summer, I was a law and racism student of Professor Angela Bell, where I was able to publish an op-ed based on the issue that brings us all here together today. The title of that op-ed is "The Wall That No One Noticed, Blocking Entry of Jurors of Color." Today, I am both pleased and honored to introduce our next distinguished speaker, Mr. Will Snowden. Will is the director of VERA's New Orleans office. Prior to joining VERA, Will was a public defender for 5 years, representing New Orleanians in all stages of a case, from arraignment to trial. Will also developed a focus and specialization in advocacy around reforming procedures, systems, and policies around jury duty in an effort to promote diversity and representativeness in the jury box. Will also launched the Juror Project, an initiative aiming to increase the diversity of jury panels while changing and challenging people's perspective of jury duty. Will everyone please help me welcome Mr. Will Snowden.
Thank you, Victoria. I want to dive in with a conversation about the types of civic duties that we frequently talk about in our country. There's a lot of conversation, at least it used to be when I was younger, about military service being a civic duty. There's frequently conversations about voting as an important civic duty. And the kind of forgotten stepchild of our civic duties is jury service. And I know everybody on this call, either perhaps themselves or maybe you know somebody who has tried to get out of jury service. And one of the things that we want to do is really change people's perspective of jury service, because it is a unique access to power that can help improve the fairness of our criminal legal system. I want to go over 4 different areas with you all in terms of the things that I've seen contributing to the lack of diversity on our jury panels. The first kind of contributing factor to the lack of diversity on our jury panels is the way that we summon jurors. So most jurisdictions use voter registration and DMV records, and we have to question that. If we look at the requirements of an individual to serve on a jury in the state of Louisiana, and actually most states, you have to be 18 years of age, you have to understand the English language, and you have to be a resident of the parish or the county where that trial is taking place. So then we must ask ourselves, why do we use DMV records and voter registration records to be the list to decide who meets those qualifications or who we should be summoning for jury service in the first place? There's nothing unique about knowing how to drive a car that makes you more eligible to sit on a jury, but we know that to have a driver's license, that there can be some socioeconomic inequities that can apply with that particular qualification because not everybody owns a car. Similarly, using voter registration lists as a source of names for people to serve on a jury, being registered to vote, we know not everybody is registered to vote. And we also know that there have been certain barriers put in place to try to prevent people from registering to vote in the first place. And so we think about one of the contributing factors that contributes to the lack of diversity on our juries is just the list that we use to summon jurors in the first place. So what alternatives could we use? Well, from across the country, we've seen different jurisdictions use, state IDs, unemployment benefits, people who have filed for their income taxes, utility bills, child support payors, child support payees, in addition to the DMV records and the voter registration records. And I believe in Massachusetts, they use something called an annual resident list, which is kind of like a mini census for the state of Massachusetts, which allows an updated version of names of people who live in those respective counties. A second contributing factor to the lack of diversity on our juries is the voir dire process. And as we know, the voir dire process is the conversation that takes place between the attorneys in the case and the potential jurors. And from a strategic perspective, the attorneys are trying to ask questions during the voir dire process, during jury selection, to essentially see who would be a good juror for that case and who might not be a good juror for that case. As mentioned in my bio, I was a public defender in New Orleans before my work at the Bureau Institute of Justice. And a frequent question that I would hear from prosecutors would be, how many of us have had a bad experience with the New Orleans Police Department? Now, we know when that type of a question gets asked in New Orleans, what I would see were the majority of the Black and brown people talking about their bad experience with the New Orleans Police Department. But then the assistant district attorneys would use those affirmative answers to either exercise a cause strike or maybe a peremptory strike to remove those people from the jury. When we think about the Sixth Amendment and how it says that you have a right to a jury of your peers, well, guess what? That includes the people in our communities who have good, positive relationships with the police departments, but also people who might not have as much positive relationships with the police departments, because we want to see individuals kind of at opposite ends of the spectrum, because that's going to lead to a more rigorous conversation in the deliberation room. But also, if you have somebody who perhaps has been a victim of police brutality or police misconduct, having that perspective in the deliberation room, the person can say, listen, I know what police misconduct looks like, and this is not it. Or, yeah, I know what police misconduct looks like, and this is exactly what happened to me. Whatever it is, the Sixth Amendment to our United States Constitution requires this, this jury of our peers, and we have to be critical of the ways in which those peers that might not be seen as favorable through the eyes of prosecution are being removed from the jury. The third way in which diversity is being removed from our juries is felony disenfranchisement. So we had the privilege of working with Voice of the Experience this year, working on legislation that was restoring the jury right to people with felony conviction. And we know in Louisiana, I believe in 2018, the law was changed to restore the voting right to people with felony convictions. And although in 2018, the voting right being restored, the jury right, which is often wed to the voting right, was not explicitly restored. So we were excited to see that change happen in Louisiana. But there are a lot of states throughout the country that do not allow people with felony convictions to serve on a jury. And I remember when being at the Capitol, this was actually maybe 2019 when a similar bill was first introduced. A state representative said, why would we give these this is his language, these criminals, these convicts, these felons, the right to vote. The right to serve on a jury. And my response was, well, you just gave these formerly incarcerated people with felony convictions the right to vote for you as a state representative, the right to vote for their judges, the right to vote for their district attorneys. So how can we not give them the right to sit in the position on a jury to vote for guilty or not guilty for their fellow neighbor? And although we weren't successful in 2019, very excited with that partnership with Voice of the Experience to get that bill passed this year. And the same amount of people who were able to have the voting right restored in 2018 is roughly the same amount of people who will have their jury rights restored after this year's legislation. The last kind of contributing factor to reducing the diversity of our jury panels is our own individual perspectives. I can't tell you how many times I have received calls or text messages from people that complain about getting jury service and then try to figure out how to get out of jury service. And I get it. Sitting in a jury lounge with cold coffee and crappy Wi-Fi is not the most exciting thing in the world. But what's important to know is that you as an individual, that doesn't work within the criminal legal system. You don't have to be a lawyer, you don't have to be a judge, you don't have to be a governor, but you as a barber, you as a teacher, you as a banker, you have the ability to show up, bring your experience and perspective to that deliberation room and help contribute to the fairness of somebody's trial. We are very familiar in this country with the benefit of diversity in our classrooms, right? We have a lineage of Supreme Court cases talking about the benefit of diversity in our classrooms. We also know the benefit of diversity in our boardrooms. I believe for the sake of the fairness of our criminal legal system, we have to be very intentional in understanding the value of the diversity of our jury deliberation rooms, because it is that diversity that is going to lead to more fairness in our criminal legal system, which is something I know we all want. Thank you.
Hello, everyone. My name is Jada Wisdorf. I'm a second-year law student at Southern University Law Center. I was a student of Professor Bell's in her Law and Racism class over this past summer. I'm also the author of the op-ed titled Ban Uncle Ben's from the Jury Box, and I am honored to introduce our next speaker, Tom Aiello. Thomas Aiello is an associate professor of history and African American studies. The bulk of his courses relate to all measures of African American history, from early slavery to Black Power. His research interests are broader, covering 20th century United States cultural and intellectual history and 20th century African American cultural and intellectual history in a variety of different settings. Please welcome Tom Aiello.
Hi, everyone. It's great to be here. My relationship with jury service in Louisiana is most directly related to the history of non-unanimous criminal jury verdicts because of Jim Crow's Last Stand and the Maxey and Ramos cases. And the failure of a more universal reckoning for retroactivity means that despite successes on that front, the legacy of non-unanimous jury verdicts is still all too real for hundreds of prisoners now incarcerated in the state. And part of that legacy was built on white fears of Black jury service. The Baton Rouge Advocate wrote just before the Constitutional Convention of 1898, "It is unfortunately too true that too many Negroes serve on juries in this state, and the interests of justice are not subserved thereby. Even intelligent Negroes in this state prefer to be tried by white juries, as they feel that in such cases the evidence will be properly weighed and the verdict reached will be in accordance with the testimony. While in the majority of instances, the Negro juryman is governed by his feelings rather than by the law and evidence." And in responding to that kind of call, we see exactly what Dr. Bell mentioned in her presentation. Members of the 1898 convention specifically asked the Secretary of State for a racial breakdown of voters by parish, and in New Orleans by ward, coming to the conclusion that 14.7% of eligible voters were Black, and thus 14.7% of potential jurors were Black. And the best method to override that possible percentage was to mandate that only 9 of 12 jurors needed to agree to convict 75% of the total. So Black jury service was suppressed and worried over by white leaders from its inception. Even more problematic is that while jury unanimity is now required, jury selection and its own distinct history of discrimination is still very much present in the system. Throughout the last decades of the 20th century and into the 21st, certain judges in Louisiana's federal Eastern District would intentionally schedule start times for court at 8 o'clock in the morning rather than 9 o'clock, because they discovered that it was harder for the urban New Orleans minority population to arrive by 8 o'clock because of public transportation issues. By starting at 8, they would get a jury pool from other, more white and rural parishes outside of the city proper, juries that would be more conservative and willing to convict. This practice still goes on today, and it does so without technically excluding anyone from calls for jury service. By limiting the jurors that attorneys can choose from, they artificially rig the whiteness of the jury. It is a subtle way in the late 20th century of doing what the Baton Rouge Advocate was calling for in the late 19th century. And things haven't improved much in the 21st. Over in Baton Rouge in 2019, it was discovered that East Baton Rouge Parish had been systematically eliminating 18 to 25-year-olds from jury service, stemming from the murder trial of Grover Cannon, whose case had originally been in Caddo Parish, but was moved to Baton Rouge because of publicity in the Shreveport area. His argument that there were no young people in the jury pool revealed what officials called a computer glitch that had not included any young people for jury service since 2011. Since studies of jury service have demonstrated that younger people are more likely to acquit defendants, many looked at the claim of a computer glitch with a jaundiced eye. And rightly so. At least one prisoner in Angola today, who I'm in contact with, was convicted in 1992 by a jury pulled from a pool in that parish with no one under 25 and about 90% white. Based on the state's history of jury exclusion, it isn't unreasonable to assume that the practice had been going on well before 2011. Then there is the case of Floyd Allen, convicted in 1996. In the process of his habeas litigation, his attorney, Wiley Beavers, discovered a training booklet for East Baton Rouge Parish District attorneys on how to use street names and zip codes to discriminate against potential Black and minority jurors. Floyd Allen was released from prison in an agreement that included suppressing the training manual. Beavers died in 2018, along with, presumably, any extant copy of that manual. The federal courts in the state aren't any better. They pull jurors from a pool that consistently underrepresents the Black population. According to filings by Richard Bork, who is here with us today, in March 2017, in the Eastern District of Louisiana, the court's qualified wheel was only around 19% Black and 77% white. Meanwhile, the population of the 13 parishes that make up that district was 31% Black and 64% white. All told, there were 236 fewer Black jurors and 244 more white jurors than there should have been in an equitable system. March 2017, however, is not an isolated incident in Louisiana's Eastern District. From 2013 to 2020, the court has generated 131 qualified wheels and has every single time underrepresented Black jurors and overrepresented white jurors. The Eastern District responded to these disparities by modifying its selection process to include driver's license as a jury pool source, but Dr. Snowden has already explained to us why that is an inadequate fix for the problem. And even while pulling from voter registrations, the NAACP's lawsuits against former Louisiana Secretary of State Tom Shedler, particularly from 2011 to 2013, have laid bare a systemic program in the state of discouraging Black voter registrations even when they're technically legal. And so the problem persists. Ending non-unanimous criminal jury verdicts is a big deal. And the work of leaders like the current New Orleans District Attorney and others is vital, beneficial change that can only help the state's jury system. But the systemic historical problems associated with minority jury service is bigger, uglier, and more subtle than that. And there is much more work to be done.
Hello, everyone. My name is Brittany Dunn, and my op-ed, Forced to Play the Wheel of Misfortune, has been published in the Big Easy magazine. I encourage everyone here to read the articles and learn and expand on everything that is presented here today. And just encourage other people to take the charge and report for service as all of you have today. Thank you.
Our next speaker is Ms. Sherry Johnson, who is the Assistant of the Clinical Programs at Cornell Law School. Sherry Lynn Johnson is an expert on the interface of race and issues in criminal procedure and the Assistant Director of the Cornell Death Penalty Project, an initiative to foster empirical scholarship on the death penalty, offer students as opportunity to work with practitioners on the death penalty cases, and to provide information with assistance for the death penalty lawyers. Ms. Johnson also argued Flowers versus Mississippi before the Supreme Court of the United States. Please join me in welcoming Ms. Johnson.
I'm really glad to see this symposium happening, and I'm honored to be a part of it. I was asked to talk a little bit about the Flowers case, and the Curtis Flowers story is a feel-good story if you see the end of it, but it's not a story that should make us feel calm or reassured about the process of jury selection. I think I want to talk a little bit about what happened in the litigation, and then I want to talk a little bit about the takeaways. So Mississippi District Attorney Doug Evans tried Curtis Flowers for the same capital offense 6 times. The first 3 trials resulted in convictions and death sentences, all of which were overturned for prosecutorial misconduct of various sorts. And in the course of all of the trials, he had 43 opportunities to strike African-American jurors, and he used them 41 times. So he struck 41 African-American jurors. The 4th and 5th trials, though, did not actually end in convictions. That's because they were tried non-capitally, which meant he had fewer strikes, which meant there were more African-American jurors on the jury, which meant the juries hung. And when those juries hung, Doug Evans arrested 2 African-American jurors who hung the juries, who ultimately were released, but which resulted in greater intimidation of the population. In the end, of course, the 6th trial is the trial that I became involved in on appeal to the Supreme Court. And his conviction the 6th time was ultimately reversed by the United States Supreme Court. But I do think it's important to notice a couple of things about what happened before that reversal that make us feel less good about the prospect for other African-American defendants. The first thing is the evidence in this case was remarkably thin. And, I think people sometimes think, it was the In the Dark podcast that showed that Mr. Flowers really hadn't done the crime. That's not really true. They did some great work and they got some additional recantations, but the evidence in front of the juries, all of those juries, was extraordinarily weak. There was no physical evidence, no legitimate physical evidence tying him to the crime. There was no confession. There were no eyewitnesses. The motive was a ridiculous motive. He supposedly killed 4 people because he lost a minimum wage job he'd had for 3 days. And this isn't a person with no prior criminal history, no history of mental illness, no reason to think he would have done this. And then there's a crazy story of how he went across town one way to find a gun in a car that he didn't know was going to be there, went all the way across town the other way to go to the scene of the crime. There are a couple of witnesses, 4 or 5, who describe him on this journey. They all describe him wearing different clothes and at different times. The final witness is one who was able to describe Mr. Flowers, or the perpetrator, as being black and taller than another man, which of course doesn't exactly exclude very many people. So I want to point out that, it's remarkable that he was convicted on this evidence, and what happened after that, even on the 6th trial, was equally remarkable. So there's a lot of serendipity in how this case got to the Supreme Court. The first thing is, it was quite by accident that I ended up involved in this case, and I don't want to toot my own horn and say I'm such a great advocate, but I had a great deal of help.
I had a terrific co-counsel. I have a university position that allowed me to recruit students to work on the case. That doesn't happen in most cases. The second thing that happened was that although we argued about Mr. Evans' history of discriminating in the past, having been demonstrated to prior to the sixth trial, having been reversed for 3 Batson violations, the Mississippi Supreme Court failed to even mention that in their opinion. And another serendipity was that there is an African-American Supreme Court justice on the state Supreme Court who pointed this out and who dissented and said, this is why they could affirm this. So then the next serendipity is that when we applied for cert, when we petitioned for cert, Foster versus Chapman was up, and we were held for Foster versus Chapman, which is not very similar in facts, but it's another Batson case. And then we get a reversal and a remand to the Mississippi Supreme Court, along with 2 other cases in light of Foster. And in the 2 other cases, the courts pretended at least to seriously reconsider their case in light of Foster. But the Mississippi Supreme Court, fortunately for Mr. Flowers, did not. Instead, they said, Foster has nothing to do with us, and then they literally pasted in their prior opinion. That, I think, made the Supreme Court mad, and that led to the next cert grant. And at this time, of course, the In the Dark podcast was also chugging along, and it became obvious to many people that Mr. Flowers was innocent as well as the subject of racial discrimination. And so what happens in the Supreme Court once cert is granted is not all that remarkable. It was nice to have 7 votes for reversal, surprising to have one of those from Kavanaugh and one from Alito. But in the end, once it got to the Supreme Court, it was not surprising that it was reversed. No one wants to be the ally of Doug Evans. No one wants to be in favor of executing an innocent man. But the problem with that is that these things that happen, all these things that happen, are not likely to happen for other defendants. So something really great happened when the conviction was reversed. There was a new Mississippi Attorney General. Why was there a new Mississippi Attorney General? Because the old Attorney General had run for governor, which he lost, which led to the Republicans taking over the Mississippi Attorney General position. They looked at the evidence again, and when they looked at the evidence, they decided not to prosecute the case again. More than that, a court ultimately gave Mr. Flowers $500,000 for his wrongful conviction. That's a Mississippi state court. Not much compensation, maybe for 23 years on death row, but a good end. The problem with the end of this story is what it sort of misses in between. I think there are 4 sobering takeaways, all of which bear on the question of whether Batson adequately protects capital defendants of color. The first is the most obvious. Curtis Flowers lost nearly a quarter century of his freedom, and nothing can give that back to him. The second is related. 4 juries, 4 of them convicted him and sentenced him to death, despite trials that failed to establish a motive, failed to produce reliable physical evidence linking him to the crime, failed to present a coherent story of opportunity, and revealed at least one other suspect who was more likely to have committed the crime. White juries, honestly, cannot be counted on to fairly determine the guilt of people of color. Now, it might be objected that most capital defendants are factually guilty, and indeed, most of them are. But that's small consolation to those who are not. And even for the factually guilty, it is not apparent that why juries that cannot be trusted to make a racially neutral determination of guilt can be trusted to make a racially neutral determination of aggravating or mitigating evidence. And indeed, both field studies and mock jury studies show that they can't. Moreover, the decades-long story of Mr. Flowers is also a story that shows that communities cannot be trusted to select prosecutors who will make racially neutral decisions. Remarkably, Doug Evans, despite his horrible history of racial discrimination and his history of lying in the cases and his history of prosecuting an innocent man, stood for re-election unopposed. I find this at least a little discouraging. And finally, I think any belief that Batson, which does forbid discrimination in the exercise of the peremptory challenge, any belief that that is really going to right racially motivated wrongs of prosecutors like Doug Evans has to sort of fail in light of the string of serendipitous events that led to the Supreme Court reviewing the case. That just doesn't happen for most defendants, and without those crazy coincidences that led to the final Supreme Court review, Mr. Flowers would have been executed by the state of Mississippi, as many other defendants are.
Hello, my name is Monet Howard. I am a student of Professor Angela Bell's Law and Racism course, and I'm also a student here at Southern University Law Center. And I have written the op-ed. It's called When Mississippi locks the voting booth, it seals the jury box. It is my esteemed honor and pleasure to introduce our next speaker's video, Miss Kenyatta Bartholomew. She created the next video that we're going to see. It is something I truly believe is going to change the way that a lot of people are going to realize that jury systems, jury booth, being on a panel is going to be the game changer for the next decade, including people of color. So without further ado, Miss Kenyatta Bartholomew.
Also, the video that we're seeing next is a project that Kenyatta completed for Law and Racism.
Is anyone else not able to hear? I'm having trouble hearing the video.
Yeah, I'm trying to hear it too. Maybe we can start it over.
Yeah, there is no sound. We're aware of that. The students are trying to get that corrected.
Thank you. Take your time.
There's somebody in the chat saying that you may need to allow sound sharing. Click on sound share.
One moment, y'all.
Okay. Let us know if you need some help. Bottom corner when you share screen is in the chat. On the left at the bottom is in the chat. Do you need some help, Kenyatta, or do you have it?
I think I have it.
Okay.
Is someone else sharing their screen?
We're seeing emails. We're seeing the clerk's office now. We're not seeing the video.
Still no sound.
We're not having any sound on this video, so what we might need to do, do we need to wait?
I don't have to miss words.
All right, we have sound now, so you can start it over.
Sis. What? Jury duty. Jury duty? Yes. Oh, I gotta think about this. I'm being all day. But they do have free lunch though. I don't have to miss work. But I'm gonna have to miss work. I don't know, man. I know this is important, but I don't really feel like being bothered with it. Maybe I should reconsider. It is, after all, my civic duty. Open the mail. I see a chance to do my civic duty. Why me, I sighed, wondering why I must go to court despite committing no crimes. But wait, why run? Away from my chance to see justice is done? Why do I cling to my need to be free, when so rarely do the 12 peers resemble me? True justice should be blind, but is it blind enough? When people of color come before a judge, it's usually one who's tough on crime, and yet, when another's on trial, they get a slap on the wrist and a fine. So no, it's not jury duty, it's jury opportunity to have real juror diversity, to quench an everlasting thirst in me, to be that voice and that peer for those who look like me.
Commonwealth's Attorney Tom Wine asked for Judge Olu Stevens to be removed from all criminal cases in a filing with Kentucky's Supreme Court Monday. The root of the debate goes back to 2014, when Stevens dismissed an all-white jury in a black defendant's case, saying the defendant could not receive a fair trial.
If I were on trial for a crime, I want my jury to be diverse. I would want to have a different group of people. I would want people from different backgrounds, like managers, CEOs. I would want millennials. And also I would like elders on my jury so that I may have different perspectives and different understandings coming to the table.
If I were on trial, I would want my jury to be very diverse. I would want them to look like me, be young, be from different backgrounds, be educated, different ethnicities, things like that. And I would like just a different, a spectrum of people. I think that sometimes juries are very biased and not understanding when there are more traditional people on the jury. So I would like for them to be more open-minded and more acquainted with the way life goes now, rather than, how it was in the 90s or even, 2000s. Like, things have changed, and I feel like we should have more of a say in how things go now, just as a young black woman. Yeah, that's it.
In a perfect world, if I were on trial, I want my jury to look like me. Have the same skin, same hair texture, same walk of life. However, I don't live in a perfect world. And ideally, I would want for my jury to be impartial, to see beyond who they think I am, and to judge me based on who I am.
The Constitution requires that men and women be judged by their peers. The context of this civil right doesn't refer to individual nuances like gender or race, rather it refers to a difference in power. When this civil right was created, it stopped citizens from being judged by the king himself and placed the judgment in the hand of the people. Now, what grants power, in my opinion, I believe education and socioeconomic status. Because with these two, inimitable opportunities are given to a person, irrespective of ethnicity or where they stay in the world. Now, these, I believe, are the foundations of an experiential commonality. So if I were on trial, I would hope that the state that invested time and money in creating a constitution to protect me would then use that same compassion to find people who could judge me fairly. Because only a person who was once hungry can empathize with the hungry. That's common sense. Don't get me wrong, I am not seeking pity, nor am I seeking to evade accountability. I only hope to drink of the little justice that is left in the fountains of America. And if I am judged by men and women with the same educational and social economics background as me, I won't be seen as a stranger or foreigner. Rather, I will be seen as a brother who fell down and only needs to be picked up by little grace and mercy.
For me, it would have to be as simple as I would like a diverse group. Of course, I would specifically want majority to be minority. Preferably women, a variety of some that are just graduating out of college and some who have already had careers. But majority, I would want the faces to represent a mixture of diverse people, as some Black, Asian, Hispanic, and so on. And I would prefer them to be not probably over the age of 50. So I would think that they would be able to be more relatable, able to, whatever the crime was, I mean, it could be a various things, but someone that is able to relate, someone who is able to put themselves in my shoes, whether it be race or gender, and be able to have a sense of the understanding and be able to look at things from all different aspects, without being biased.
If I was to go on trial today, I would want my jury to kind of look just like me. And no, not just skin color, but kind of be close to the same generation as me, if not in the same generation as me. I know that all wouldn't happen all the time, but sometimes you need your lawyer to speak to people, and they'll need to be able to understand where you're coming from or get what you're saying. So that's why I say I kind of want them to look like me.
Tonight, the demand for change is stretching beyond law enforcement and into the courtroom, where nationwide, Black people are convicted at higher rates.
They're prosecuted more, they're arrested more, they're punished more. And very few people who look like them actually sit in judgment of them.
New review of appeals involving issues with peremptory strikes finds prosecutors striking Black jurors in 72% of those cases, while striking white jurors in less than 1%. Some of the reasons? Because they had dreadlocks, were slouching, wore a short skirt and blinged out sandals, visited family members who were incarcerated, or had negative experiences with law enforcement.
I asked a simple question. What would you want your jury to look like if you were on trial? I was intentionally vague because I didn't want to influence anyone's answer. Despite having a vague prompt, a common theme emerged. People of color want diverse juries that include people who look like them. The participants, all of whom reside in the southern region of the United States, call for diversity in a number of areas, including gender, race, age, social economic status, education, and life experience. One thing is clear. We all have the desire to be judged by people who understand us. The composition of a jury matters because women and minorities often shape the outcomes by raising doubt. A study done by social scientist Patrick Bear revealed the impact that a lack of diversity has on conviction rates. In trials where there were no Black members in the jury pool, Black defendants were convicted 81% of the time, while white defendants were convicted only 66% of the time. In trials where there was at least one Black juror, conviction rates were identical, around 70%. The court has the duty to get people of color out to jury service because the right to a fair trial is an essential part of a just society. Black and brown communities are often distrustful of the legal system and its ability to offer just outcomes. The court must fulfill its duty to get people of color out to jury service in order to foster trust between Black and brown communities and the legal system. Until there is justice, we will not know peace.
During this next segment, we're going to have remarks from our co-host. We've already heard from Mr. Will Snowden, who's representing the Vera Institute today, so he will not speak again, but Vera is one of the co-hosts for today's program. Next, we will hear Mr. Richard Bork. He represents the Louisiana Capital Assistance Center.
Hey everyone, I'm Richard Burke. I'm the director of the Louisiana Capital Assistance Center. We're a nonprofit law office here in Louisiana. We've been running for 25 years. We primarily defend poor folks who are facing the death penalty in Louisiana. And as a result of that, I've been here for just coming up on 20 years. As a result of that, I've been involved for that full 20 years in investigating and trying to litigate equity on Louisiana juries and federal juries in Louisiana. And I want to applaud everyone involved in presenting this symposium. It's just been a wonderful thing to watch some of my heroes spoke, and I'm going to walk away with the phrase juror opportunity emblazoned in my mind. I'm never going to talk about jury duty again. I think that's terrific. And the thing that I wanted to make clear to people is how important understanding some of that history that Angela and Tom brought in, because it's not just history. I've been litigating here for close on 20 years on these issues. We have investigated the makeup of juries across this state in parishes from north, south, east, and west of the state and in federal court. And everywhere we have investigated, we have found significant underrepresentation of people of color. Nowhere is the fair cross-section guaranteed by the Constitution being found in the state of Louisiana in state or federal court. And the other important thing to understand is that when you prove this in court, you meet with antagonism and hostility from the prosecution and from the bench. We've had some wins, we've had some losses, and we've seen policies changed. But people don't want to accept this reality and they don't want to do anything about it. The prosecution in this state, not all of them, but have a historical commitment to removing people of color from jury service. We've studied disparate peremptory challenges, the sort of thing that was happening in Curtis Flowers' case, and it happens routinely in Louisiana. Black people struck from juries, people of color struck from juries by prosecutors who are no more committed to a fair cross-section than they are to fairly using their peremptory challenges. And in the challenge that Tom referred to with the Eastern District of Louisiana this year, showing an underrepresentation by over a third of the black community of the Eastern District of Louisiana, the court denied that challenge, said underrepresentation at that level was not constitutionally significant, and that in any event, it was essentially the fault of black folks for not turning up for jury service. Quoting a 1968 federal Fifth Circuit judge, the judge said that the practical result is that in order to be considered for jury service, a citizen must be sufficiently concerned with the operation of his or her government, either to register to vote or actually to vote and to return a completed juror qualification form. So if this community does not speak, this community will be blamed for the underrepresentation of people of color in Louisiana state and federal courts, because we know that blame.
Excuse me, I'm sorry. We're out of time and we're gonna have to move on to the next speaker.
No problem, Mike. Again, congratulations on the symposium. Thank you.
Thank you again, Mr. Board. Next, we're going to have Ms. Jamila Jefferson representing the Promise of Justice Initiative. Everybody give her a warm welcome. Thank you.
Good afternoon. On any given night, more than 1,500 people go to sleep in Louisiana's prisons, even though the U.S. Supreme Court has said their conviction came from an unconstitutional jury practice. A jury practice intended to silence the voices of Black jurors and to convict more Black defendants. My name's Jamila Johnson, and I'm the managing attorney at the Promise of Justice Initiative and the leader of the Jim Crow Juries Project. My job and the job of my team is to make sure that the state of Louisiana can heal from more than 120 years of injuries caused by these non-unanimous Jim Crow juries. Today, we represent more than 1,000 of these men and women and have hosted clinics for survivors and have done work to speak with jurors who have had their voices silenced. We have brought home more than 35 people with these convictions in the last 5 months, almost 30 of whom had life without the possibility of parole sentences or virtual life sentences. We really thank the organizers, the participants, all of the attendees today. I can imagine a world where it wouldn't have taken until 2020 to acknowledge Jim Crow juries as unconstitutional, fueled by racial hate and exclusion. And I imagine a world where together we build a stronger jury culture in Louisiana. Moving forward, and we at PJI are pleased to see this event and hope this event helps people take the next steps. Thank you so much.
Thank you again, Ms. Jefferson. Our next speaker is Dr. Clyde Robertson, Director of the Center for African and African American Studies at SUNY.
Greetings and Hotep. As you identified, my name is Clyde Robertson. I'm the Director for the Center for African and African American Studies and an Associate Professor of Humanities at Southern University at New Orleans. I am professionally a historian and an Africologist. I have spent the last 38 years of my life pursuing the history of African-derived people. I have been pursuing issues of justice and equality. I am in a world of people who do likewise. However, seldomly have I been in the presence of scholars and people who are actually looking at jury selections as a method of oppression. This symposium, as a result, is extremely significant and extremely important because for me, it has been edifying and informing. The discussion of the exclusion of Black and people of color on juries is something that very seldomly historians pursue. I'd like to read something to you. Some of you may not be familiar with William Tyler Page's The American's Creed. He says, I believe in the United States of America as a government of the people, by the people, for the people, whose just powers are derived from the consent of the governed, a democracy and a republic, a sovereign nation of many sovereign states, a perfect union, one and inseparable, established upon those principles of freedom, equality, justice, and humanity for which American patriots sacrificed their lives and fortunes. He goes on and says, I therefore believe it is my duty to my country to love it, to support its Constitution, to obey its laws, to respect its flag, and to defend it against all enemies. This was accepted by the United States House of Representatives in 1918. I submit to you that it is high time for this country to love all of its citizenry, to obey the laws and rights of all of its citizenry, and to defend against enemies all of its citizenry. Until that happens, we must continue to agitate. We must continue to confront. We must continue to fight this power structure which fights us and our right to live and exist. And so I applaud all of you in this dynamic symposium. And I beg you to continue to fight. Thank you.
Thank you, Dr. Robinson, for your contribution. Our next speaker represents the VOTE organization. Please welcome Mr. Chico Yancey.
Good afternoon, everyone. After all of this, I am struck by drinking from the fountain of justice. I mean, when you really look at it, wow, what does that really mean, drinking from the fountain of justice? First of all, my name is Chico Yancey. I work for the Voice of the Experience as the C4 Policy Director. And before I give you some history, I'd like to say thank you, Professor Bell. Thank you. Thank you. Thank you. I met Professor Bell once I was incarcerated in Angola. I've been out now 18 years. I spent 20 years in Angola. And now we are fighting for the rights of people, and all of the great speakers that's before me. Thank you for all that you do. And when we read that the Constitution and white America said we're going to do this legally and constitutionally, make sure that black folks couldn't not only serve on juries, but couldn't vote. We fought, and we fought. I have to give a lot of credit to former state representative Pat Smith, who fought 5 years for us to become registered voters. We lost 5 times, but each year she would say, we'll be back. And finally, we won the right to register to vote. It happened in 2018, and March the 1st of 2019. I could not wait to go to probation and parole, although it was a stumbling block. I had to go get my letter, and then I had to go to the registrars. And now I am a registered voter, and I don't miss an election. We fought this year to be able to, when you come off of parole after 5 years, that former incarcerated people can now serve on juries. How important is that is? You know, with the Voice of the Experience, we started Angola Special Civic Project whilst we were in prison in Angola in 1987. And from there, with Norris Henderson, Bruce Riley, and a host of other staff members that I don't want to leave out, not call anybody, but to all of our staff and the hard workers, we do a lot of work to show from chains to change, from chains to change. We have worked so hard to get all of this done. And, you know, when we look at the black juror voters and all of this, I tell people all the time. In fact, I told a family member just recently that got a jury notice. And the first thing the person said was, wow, I don't want to do that. And I had to remind them, that's why we fought so hard. We fought hard that you could be a part of the system, that you could go and do your due diligence. They want you to say no. They want you not to come. Find an excuse. But who looks better on the jury than our people? So we have to make sure that we understand what this is about. And they intentionally divide these laws. They did this intentionally, not accidentally, but intentionally. So, you know, we are fighting at both Voice of Experience. We are fighting. We have an office in New Orleans, Baton Rouge, and Lafayette. And guess what? It's all staffed by former incarcerated people that leads this fight. I am a former incarcerated person. And then last year they had a guy that tried to do some carve-outs. Carve-out is take people out with certain crimes. My crime, I did something I had no business doing in 1987. I'm a registered offender. So they wanted to take me out of the process. We fought that.
Excuse me, Mr. Yancey. Thank you for those wonderful words, but we're out of time and we have to move on.
No problem. Thank you for that opportunity.
Thank you so much. Good afternoon, everyone. We have now reached our Q&A section of the program. You have heard from our panelists and our co-hosts, but now we want to hear from you, the audience. You may place questions in the chat, or at this time, you may unmute your mic if you have any questions.
So first and foremost, there was a wonderful comment in the chat that said, as a person over the age of 65 years, I'm encouraging and challenging others to accept the call to serve as jurors if they can. In Louisiana, those over 70 can opt out without a question. Their wisdom and ability to appear are valuable. So it's very important to keep looking at the chat. There are some wonderful comments in there. There is a question in the chat. I'm not sure who this is directed to, so anybody can jump in. It says, while we have a Democratic president and Congress, wouldn't you say it would be a good time to try adding other sources of potential jurors to federal trials?
Since I talked a little bit about sources, jury sources, I'll agree. I think we do need to evaluate the lists that are used in federal court. We know that simply using voter registration is a limiting source, and part of that is by design. Right? We talked about how the effort to prevent people from registering to vote has a direct impact on those who are called to serve on the jury. So I think if there is an avenue for which this Democratic president can support the utilization of additional lists for the federal system, that potentially could be a great model for some states to be inspired by additional lists that could be used as well.
And we also have a question from Don Charlotte, who has his hand raised. Don, you may unmute your mic and ask your question.
Okay. Good morning. I guess it's still good morning when you're at. Good afternoon. My name is Don Charlotte T. Silent. I'm originally from Acadia in St. Landry Parish, but I live in California. I'm a filmmaker. One of the things that I ask questions about is, how does property ownership weigh into the selection process, particularly from a historical standpoint? One of the main topics of the film that I'm involved in involves, free people of color and property ownership, and there's a direct link to that and the Opelousas massacre from the Reconstruction period. But does anybody have any information in terms of how that weighs into the decision process? Selection process.
I'm not sure if you're asking about historically or currently, but I will mention that when we were granting the right to vote in the state, the people who were first eligible amongst the group of those of color were the free people of color. They were the people who owned property. They were the people who became the immediate targets, of course, because now that property ownership allowed them to navigate this world of political rights, and they became targets. So that historically means that when you own property, you got immediate access to the system, but then you immediately got ramifications for trying to use it. And I don't know if you're asking that historically or if you're asking currently. Because, can I answer your question?
Yes, yes, more historically, I should have been clear on that. I see that as being an issue, particularly when it came to the massacres and, as you mentioned, the targets that were placed on these people, and also the legalities of the 14th Amendment that talked about, the rights, liberty, life, liberty, and the ownership of property. So, and there's some direct, some confrontations, as you're well aware of. So from a historical standpoint. Thank you, Angela.
So, and I'll also add one quick point. Most of those massacres that happened in the state of Louisiana have well been suppressed. And it's surprising because of the mass scale loss of life. But you have one in St. Bernard Parish. We have the Mechanics Institute in New Orleans, Colfax Massacre. We have about 8 of them that have largely been suppressed. And one of the ways that this gets hidden in law, there is a case that we study in constitutional law involving the Grant Parish Massacre. But when you read the facts, it says something like there were some people who were harmed. It doesn't tell you that these people were, black voters, and it doesn't tell you that they were actually massacred, and it doesn't tell you there were 200. So law happens to suppress this history, so these stories are not often taught. But it is important for every person in this audience to understand the massacres that happen all over Louisiana and the lynchings that have still been suppressed, because if you don't understand that, you don't really see this current struggle for political rights as a continuation of a larger effort. I see there's a hand up from Sean. You can certainly ask your question. Sean, you're muted. Okay, we can hear you now.
Okay. Thank you very much for the opportunity, Prof. And thank you to all the panelists for their excellent and insightful presentations. I just have a quick question that I wanted to ask. I saw that quite a number of people, I think rightfully, were actually praising the idea of having a diverse jury in terms of that is likely to bring about a more fairer outcome. But then one of the thoughts that I had is, once we've overcome that hurdle of actually having a diverse jury, then I kept thinking about what then do we do to combat some of the problems that may arise during jury deliberations. Because one of the things that I thought about is not all of us are actually fluent, not all of us. So you have this thing of people suffering from inferiority complexes, and then you have other people suffering from superiority complex. And I think one of the people that actually mentioned something that's very insightful is Frantz Fanon, when he said that Black anxiety does not actually manifest itself when you're amongst Black people. It only manifests itself when you're around white people. So how do we combat having a diverse jury that is made up of, let's say, Black people, but then they feel as if they don't belong there. They feel as if they're inferior. They feel as if they're sort of like imposters. So that's my question. How do we then deal with that kind of psychology of inferiority?
Does any other panelists wish to respond? No one. So I'll quickly say that this is important, this imposter syndrome, because the fight to get folks of color on the jury does no good if there is a silence once you occupy the jury box. So I want to stress a few things. When the deliberations happen, there's studies now for so many years, there's no argument about the weight of that voice in the room. We know that when that person of color actually speaks in the room, they're usually the person to raise reasonable doubt. So as we do this education of understanding jury as a civic duty, secondarily, we must understand what the research is teaching us about the necessity of us speaking once we get there, because we are the people with these unique experiences, and then we are duty bound once we are there to educate our fellow colleagues on that jury about how this diversity of experience colors this evidence that's before us. So as a secondary component of what we do, we understand the research tells us that the outcomes change when we're there, but we have a duty now once we're there to understand that we have to use our unique insights and perspectives to influence this process. So it's a good question, and it's certainly one to add on to this discussion, and thank you for raising that point. I think we have time left for Ms. Brenda, and that's going to be our final question.
Thank you so much for allowing me to participate in this symposium. It's like a ray of fresh light to hear young people especially voice the opinions that they've done, but I don't want them to give up on older people serving on juries, because sometimes we might be your best ally. But one of the questions that I would like to ask, if there is someone on the panel who is aware of what type of algorithm is used to determine who serves on the jury. We're often told that it's the voter rolls plus the driver's license, and those are the different sources. But what's the actual method that is used to select people from these lists? Because a lot of people I know who would make excellent jurists have either never been called for jury duty, particularly federal jury duty. And as I understand with that one, you have to live in Orleans Parish if you're from my area. So can someone speak to what method is actually used to select people from those various lists?
So Richard Bork or Sherry, since you have done a lot of the litigation around this, would you feel comfortable responding to that? either Sherry Johnson or Richard Borg. Make sure you unmute your mic, Sherry or Richard.
I see that Sherry's hand wasn't moving to the mute button, so I'll respond.
Okay.
So Brenda, in the work we've done in Louisiana and in federal court, the problem is you run off a list from the voter roll and maybe DMV, then it's in a computer and the algorithm is set to be random. And in my experience, that's not where the big problem lies. They then spit out a list of addresses they're going to send out juror summonses to, and that's where the big problem comes in. Those addresses are not up to date. They're not fairly, they're a reasonable representation of the list they're drawn from, usually. It's been a long time since we've seen clear examples of people putting a thumb on the scale that way. The thumb on the scale is that for people of color who are more frequently renting and more frequently moving in their homes, more frequently living in less socioeconomically favored areas, the reliability of those addresses in the mail means that people of color aren't getting those jury summonses, and so they're not able to respond and play their part. And so that's the single biggest chunk of it.
I'd like to believe that, but I have evidence to reveal that some people who have lived in their homes for decades, never moved, voted continuously, always had a driver's license, living in mixed neighborhoods. So I know that some of what you're saying is true, but I think that until we can look at those things and verify, it's still questionable on my part.
I wanted to say two more things quickly. One of which is, I do think it's possible that jury summons are taken out of people's mailboxes. And I know that Richard was concerned about that possibility earlier, and I don't know how to investigate that, but I do think that is one worry. The other thing I wanted to say is only tangentially related, which is that once you do actually get to jury selection, I'm going to say that prosecutors look for reasons to strike African-American jurors. And if you're a person who's called, you want to give them no reason at all that they can use as a pretext. So you would not want to come wearing a t-shirt that said anything unusual. You would not want to nod at the defendant just out of the courtesy that you might as a human being. You would not, you want to behave as conservatively as you can. And while I think that's atrocious, that those are reasons that are given, and atrocious that those are reasons that are accepted, I want to say for people who want to serve on juries and want to do the duty of justice, you're more likely to serve if you avoid anything that a prosecutor could cite as a reason to strike you.
Thank you so much for those comments, Ms. Johnson. So now, as we come to our close, Frederick Douglass once said, "A man's rights rest in the three boxes: the ballot box, the jury box, and the cartridge box." In the spirit of Frederick Douglass, it is time to recognize our role in these boxes to bring equality and equity for all. In moving forward and making these changes, it is up to defense attorneys to raise challenges when preemptory strikes are made solely on the basis of race. Prosecutors must be ministers of justice. They must seek justice instead of convictions. Reform needs to begin on the inside. Courts and clerks need to ensure their methods for selecting a jury ensure a fair cross-section of the community in jury pools. The need for change does not lie within the hands of the people with title and position, but with every civilian. It is your civic duty to educate the uninformed. You have resources available to you today. Share the video that was shown today. Share the articles and the op-eds written by the students here today. You may also follow and book Will Snowden, the founder of the Juror Project, who we heard from today. Finally, I'd like to thank everyone who was part of the effort of this event today: Professor Alan Bell, Kenyatta Bartholomew, Brittany Dunn, Victoria Gonzalez, Monet Howard, Alexis Sherman, Amari Spraggins, Jada Woodstorff, and myself. Unfortunately, Mr. Trevino was not here with us as his family has been affected by COVID-19 with the loss of a loved one. Thank you again for your attendance and your participation. On behalf of the committee, it was an honor.
Thank you, everyone.
out and register and serve on the jury.